Hello, and welcome to Identifying and Prosecuting Power of Attorney Abuse. Q&A will take place at the end of the presentation. Just a quick disclaimer to let you know that the views expressed in the presentation today are those of the presenters and do not necessarily reflect the views or positions of the U.S. Department of Justice. I'll now turn things over to Naomi Karp of the Elder Justice Initiative.
Great. Thank you so much, Talitha, and delighted to be here with all of you today. I'm Naomi Karp, as Talitha mentioned. I'm a consultant with the Department of Justice's Elder Justice Initiative. I'm an attorney with over 30 years of experience in the field of aging law and policy. Before we dive into the materials, I wanted to give you a very quick overview of what we're going to cover today and our speakers. I will talk just very briefly about this slide on the Elder Justice Initiative. Then I will present some background on powers of attorney. Then we will turn to prosecuting power of attorney abuse and elder financial exploitation from the federal perspective, and our presenter on that will be Tim Vavricek. He is an assistant U.S. attorney in the U.S. Attorney's Office for the Northern District of Iowa. Then we'll talk about state-level approaches to prevention and response, and our speaker for that portion of the webinar will be Chantelle Smith, an assistant attorney general in the Iowa Attorney General's office. So just briefly, the Elder Justice Initiative's mission is to support and coordinate the Department of Justice's enforcement and programmatic efforts to combat elder abuse, neglect, and exploitation. We have lots of different resources for lots of different types of professionals, prosecutors, law enforcement, other professionals as well. We have a robust website at elderjustice.gov where we have outreach materials. We have a lot of materials for prosecutors. We have a compendium of research on elder abuse. We also have a compendium of state laws on elder abuse. We provide help for multidisciplinary teams, or MDTs, around the state. And we have lots of webinars which we have archived on the website, so we hope you'll take a look at it. So let's move into our topic today for power of attorney abuse. Let me go over some basics on what a power of attorney is and a little bit about power of attorney abuse generally. So we are talking today about a power of attorney for finances, or a financial power of attorney. It's a legal document that an individual will sign to allow someone else to manage money and property on their behalf. It's often used as a tool for planning for future incapacity. So a person might in the future get dementia or some other type of illness and not be able to manage their money. There are many forms of power of attorney abuse. And the first three forms that you see listed on this slide are where a person has legitimately granted power of attorney to someone else, but that other person is abusing their powers. So there are a number of different ways that they would misuse the power of attorney. The first is self-dealing. In other words, they would use their authority to spend the individual's money on items or actions or activities for their own use rather than for the individual's needs, and that would be a violation of their fiduciary duties. Secondly, they might exceed the scope of the authority that that person has given them. So for example, the power of attorney document might not give them the power to make gifts, but they might use it to make gifts despite that. And third, they might use it in a way that would deviate from what the person actually intended when they created the power of attorney. So for example, they might have wishes for what would happen to their money and property after they die, They might want it distributed equally, let's say, to their children, but the agent might make gifts or transfers that would undermine that those desires. So those are all ways that they would misuse a power of attorney. But in addition to that, the power of attorney document itself could be a forgery, or it could be fraudulent in some other way. For example, the perpetrator might use undue influence to get the victim to sign the power of attorney. So they didn't actually really want to, but they were forced or hoodwinked into doing that. And also, the individual who signed the power of attorney might not really have had the cognitive or mental capacity to know what they were doing. So they may have signed it, but really not understand what the document is or what powers they're giving away. So those are some different types of power of attorney abuse. So you might often hear of a power of attorney being referred to as durable or a durable power of attorney, and most powers of attorney today are durable. What that means is that the document is still valid and the agent still has the authority to act even after the principal, the person who signed the power of attorney, no longer has the cognitive ability to make financial decisions. In fact, that's why many people have a power of attorney, so that it is durable and it gives someone the opportunity to act after they can no longer act on their own behalf. The document itself is the thing that describes what the agent has the power or authority to do. It lists them. And a power of attorney document can be tailored to the needs of the person. So if the person did or did not want the agent to have the ability to change beneficiaries, say on an insurance policy, or to make gifts or things like that, those would be things that would be laid out in the document. In many states, there is a form power of attorney, but it's not usually mandatory to use that form, and many people have a lawyer draw up the power of attorney on their behalf and make sure that it meets their needs. I wanted to make sure everyone understands that a healthcare power of attorney, while also called a power of attorney, is different. That gives someone else authority to make healthcare decisions on your behalf. It's also sometimes known as a healthcare proxy. But the kinds of powers of attorney that we're talking about today are for finances. Okay, we will move ahead. So why is it easy to commit power of attorney abuse? Sometimes powers of attorney are called a license to steal, and that kind of gives you that idea that it is very easy to use them and commit power of attorney abuse, and you'll hear about some case examples today. It gives the person broad decision-making authority, but there's generally no formal monitoring over the person exercising that authority. So for example, with a guardian or a conservator who are appointed by the court has the authority to oversee it and can require the person to file accountings and reports, and that's usually mandated by state law. But with a power of attorney, that is not the case. It's a private arrangement, and there's often no one looking over that person's shoulder. Often the person who signs the power of attorney, makes the power of attorney, isn't really even aware of how risky it might be. And many times the abuse might go on for a considerable period of time before somebody detects it. Now, this may make it sound like no one should have a power of attorney, but they are actually very important planning tools, and they are important for people to be able to conduct business. We just want to make sure that people who use them are honest and act on behalf of the person who named them. Just quickly, the role of state law. Generally, state law, not federal law, is what prescribes the basic requirements for powers of attorney, what form it's in, whether it needs to be witnessed, rules about, whether you can have more than one person, how you revoke a power of attorney. That's generally state law. And state law may have provisions that actually have a beneficial effect in limiting or preventing power of attorney abuse. So for example, there is a uniform law, which is a model law, the Uniform Power of Attorney Act, and now it's been adopted in over half the states. And it permits a third party, such as a bank, to refuse to honor a power of attorney if the bank suspects it's being abused and if the bank reports it to Adult Protective Services. So there are other provisions there also that aim to prevent or respond to power of attorney abuse. So now I'm going to turn it over to Tim to speak from the federal perspective.
Thank you. My name is Tim Vavricek. I'm an assistant U.S. attorney in Cedar Rapids, Iowa, here at the U.S. Attorney's Office for the Northern District of Iowa. We're a relatively small federal prosecutor's office, and I'm one of a handful of people who do fraud type cases, and I'm happy to be here today to talk to you all about elder financial abuse. Just a little bit of background. Our office, for those of you who aren't familiar with Iowa, we're about the northern half of Iowa. I'm here in Cedar Rapids, Iowa. We also have a branch office out in Sioux City, and we're currently under an acting U.S. attorney, Sean R. Berry. So one of our office's priorities over the years, regardless of who the U.S. attorney's been, has been to combat elder abuse, elder financial abuse in particular. One of the sort of impetuses for that was back in 2016, our district was chosen as one of I believe it was 10 regional elder justice task forces. And so we have made it a particular priority since 2016 to identify any ways that we could help combat elder financial abuse. Now, it's absolutely correct that these powers of attorney are created at state law. But one of the things that we've found is that sometimes the use of those powers of attorney can cross certain red lines in the federal criminal law as well. Why is this important to our district? Our district in particular has a high elderly population. For those of you who aren't familiar with our state, we are in many respects rural. 17% of Iowans generally are age 65 or older, and many of those people are in situations where they are alone or have other issues going on that may make them particularly vulnerable to being abused financially. So what is, at the end of the day, a crime? Well, a financial crime. Well, if you just get down to it, it can be lying, cheating, or stealing, as just a practical matter. And with respect to powers of attorney, they can be very dangerous and effective instruments of fraud, because when they are in the wrong hands, if they, depending on how they're written, they can pretty much give carte blanche authority from the principal, the person who's giving the authority, to the agent, the person with the power of attorney in their hand. And one of the sort of prejudices I think we see in this area historically is the idea that these powers of attorney are just simply civil matters, that the criminal law should have nothing to do with them. If you have a power of attorney from someone else, that's between the principal and the agent, and the criminal law should have no effect. At most, there may be a civil remedy such as a breach of fiduciary duty lawsuit, but that the role of law enforcement just really shouldn't be there at all. And but what we've discovered is that is certainly not the case. In some cases, for example, the signature could be forged. I mean, that would be the most extreme example, where the power of attorney itself is just completely invalid because it was never signed. Or the principal was clearly lacked the authority, the capacity to sign such an instrument due to mental health or other issues. Another thing that can happen is that the power of attorney is not followed on purpose, fraudulently, that the person gets the power of attorney on the pretense that they're going to help the principal, but in truth, it was just a ruse to get at the principal's money for the benefit of the agent. I won't go into the details of all these federal crimes and statutes, but with respect to the statutes available, we have statutes, familiar statutes that have been around for 100 years or so: mail fraud, wire fraud, and bank fraud, which the Supreme Court has made pretty clear are designed to touch at schemes to defraud, and the human imagination can be quite wide and varied on how to steal other people's money. But if the mails are used, the Postal Service or FedEx or UPS in some way, or if there is a wire such as an email, or it could be as simple as the ACH transaction in a bank that crosses interstate lines, then the federal government may have jurisdiction over these. Of course, it is a crime to lie to a bank about a matter, and it's also a crime in connection with any of these statutes to be using someone else's identity. Under all these statutes, one of the elements is something called intent to defraud. And that's simply to act knowingly and with the intent to deceive someone in order to get money for yourself or to take money away from someone else. So that is one of the elements there. I'm now going to talk about 3 case studies from our district that we had with respect to combating power of attorney abuse through federal prosecution. In the first case, a power of attorney was used to defraud an elderly widow who resided in a nursing home of more than $500,000. In that case, the perpetrator was sentenced to 70 months in federal prison on 1 count of wire fraud. In that case, the perpetrator obtained the power of attorney despite knowing that her victim clearly lacked the capacity to understand her actions due to severe cognitive and physical disabilities. This goes back to that the power of attorney itself was a fraudulently obtained instrument. It was never good. And the power of attorney was used to drain the victim's account for the perpetrator's own benefit. And in this case, there were a series of purchases that were made in other states, resulting in interstate wires on a debit card, I believe. The second case that I had here, a power of attorney was used to defraud an elderly disabled veteran and nursing home resident of over $120,000. This perpetrator was sentenced to 27 months in federal prison on 1 count of wire fraud again. Another similar pattern here, the victim signed the power of attorney form despite obvious cognitive and physical disabilities that were known to the perpetrator. So this wasn't a mistake or an accident. There was some discussion earlier about the form. We have in Iowa, like many other states, what we call a bar form. It's a form that if you went to a lawyer, you would pretty much always see the principal and the agent using for a power of attorney form. And on that form, there's an option, and it usually always checked or used, that the agent cannot make gifts to oneself. And so in this case, when we're looking for intent to defraud, if there's a representation, a promise that the gifts won't be made to oneself, and the perpetrator knows that the principal is not in a position cognitively and physically to sign the form in the first place, and then immediately thereafter the funds are drained for the agent's own benefit almost exclusively, we found that to be compelling evidence of intent to defraud, and in these cases the individuals have pled guilty. In this case, the victim lost his life savings and was unable to pay for his nursing home care. There are enhancements in federal sentencing law if the victim is deemed, quote, vulnerable, end quote, or if the person loses essentially all of their money, a substantial financial hardship. There's also an enhancement for abusing a position of trust. And in our circuit, in our district, the probation officers and the judges have been routinely applying all of these enhancements now in these cases, which increases the sentence that the defendant is recommended to receive under the guidelines, at least. The final study I had here was a married couple who used two power of attorneys to steal over $200,000 from the husband's elderly mother. They spent all of the victim's funds for their own benefit, and the victim could no longer afford to live in an assisted living facility and had to move in with her perpetrators. This person had the cognitive ability to sign the form. It's just because of her situation, she didn't know what her son and daughter-in-law were doing with her money. And so this would be a case of exceeding the scope of the power of attorney. In this case, the victims, in 3 months after the victim had to move back in with them, the victim lost 23 pounds, broke her wrist, was hospitalized, and later died. Obviously, this is a bit of an extreme example, but it does show how financial abuse and physical abuse can dovetail with one another. Briefly, in the few minutes I have remaining, and I do appreciate everyone who, it appears there's a number of audio issues. We apologize for that on my end. Some red flags. Things to look for is the principal in the power of attorney relationship, the victim, isolated. With respect to the agent, do you see someone who suddenly has wealth or lifestyle changes? Someone who doesn't appear to have the means that suddenly is driving expensive cars, jewelry, homes, clothing? Or behavioral changes in someone. Sometimes these funds that are stolen are due to an addiction to narcotics or gambling in particular. Or someone who has historically had problems with money. One of the other things we've noticed is with the perpetrators is people who seem to be overly interested in the elderly person's finances. Sorry, I was apparently going too still and my lights went out. Someone who's expressing too much concern perhaps over the cost of care doesn't want to be spending money for necessities. A number of these cases are reported to us, sometimes by the nursing home, because they're suddenly not getting paid and they believe that the person in the nursing home should have money, and suddenly there's no money. Again, this theme of the elderly person being isolated, or sometimes it can be isolated yet controlling. So, for example, a bank, someone working at a bank might note that the elderly person who they might know in a small town has always come in to get some, write a check or something for a grandchild, is suddenly always accompanied by someone who has this power of attorney and is no longer allowing the elderly person to speak for themselves, and maybe there are highly unusual transfers going on in their bank account all of a sudden. Often we'll see the elderly person may be concerned or confused about missing money. There may be suspicious signatures on checks and the like. A lot of times, one of the things we'll see is the power of attorney is not just used to make a particular transaction, but the power of attorney, and this happens in legitimate uses of power of attorney, is you need to get on the bank account. And so you'll see the power of attorney presented to the bank. You'll get someone as the power of attorney jointly put on the bank account, but then perhaps transfers start moving into accounts that are solely in the agent's name, accounts that have nothing to do with the principal, and then those accounts are where the money may be spent. I put my contact information up there. Please don't hesitate to reach out to me. I'm happy to talk with folks. This is a subject of particular interest, not only to our office, but to myself personally. I thank you. Thank you for your time.
Well, thank you everybody for being here today. I could talk for days on this topic. I think maybe I have talked for days on this topic. So we'll try to get through this relatively quickly so we can, while covering it, but to make sure that we have time for your questions, because I know there are questions coming in. I am in the Consumer Protection Division of the Iowa Attorney General's Office. I also represent the Long-Term Care Ombudsman's Office, and I think have represented every state agency that has some involvement in the lives of older Iowans. So that's the lens with which I look at this topic. And like Tim, Tim used to be in the AG's office too, so I've known him for quite a while. It is an area of passion for me, and the POA issue in particular, and to be highly annoying in many regards, which we'll talk about. So investigation and prosecution at the local level. I've noted here, a reported suspected crime is a crime, or is it? I'm not sure that it is when it comes to these cases. We see these cases reported to law enforcement, and we see them fairly often kicked right out, as though stealing from someone using a POA isn't theft for some reason. And we'll talk a little bit more about that. But just to put that out there, I'm not sure the answer is that a crime is a crime is a crime. I think that in the eyes of law enforcement and many prosecutors, these are different somehow, and possibly often not crimes. We also see issues with whose case is it? Who initiates it, who develops it. And that ties back to what I was saying before. If you're not viewing this as a crime in the traditional sense, what is it and who picks up the case? I think a lot of law enforcement thinks that these are adult protective services cases, and therefore not something that a detective or an officer is looking at. So then they're waiting for something to come to them, they being law enforcement, waiting for something to come to them, and often waiting for it to come in a gift with a bow and perfect wrapping around it, which we all know is not how it works. But that is what we're seeing, which gets us to the point of, the question of, are these adult protective services cases? Are they elder abuse cases? Are they plain old theft? Insert whatever the crime is. What are they? Can they be all of those things? In Iowa in particular, we don't have a criminal elder abuse law. We have dependent adult abuse, which covers people 18 and over, adults who are 18 and over who have some sort of dependency as defined by statute. Then we get in the loop of, well, what if they're not a dependent adult? So now we're talking about elder abuse. And then we get law enforcement and prosecutors who step back and say, wait a minute, I don't know what to do with elder abuse. Maybe I know what to do with dependent adult abuse, but we're lost. At the same time, I'm looking at them saying, well, what about theft? What about assault? What about harassment? So we're having those conversations and we're having those struggles. And based on my experience talking to other states, Iowa is far from alone. These are the conversations we have every time the states get together. Continuing with challenges and barriers, Tim referenced the civil versus criminal dichotomy. No shocker there, right? I would assume everyone who is on this webinar, if they've done any of this work, has heard that. It's civil, it's not criminal. I get many calls from family members who say, we called the police and they told us it's a civil matter, especially when we're talking about a POA. It is, in fact, a private agreement. It is, in fact, a document that is drafted by one person that involves another person or multiple people. It's not government regulated. It's not court supervised. That does not make it purely civil. We have these conversations all the time. Most of the time, we're seeing things that are civil and criminal. It's both. The victim could file a civil action, but the victim has also been a victim of a crime. So changing that way of thinking has proven to be quite a struggle. Another thing we're seeing is, I see this a lot. We often don't have a clean report, is what I call it, of what's happening to the victim. And I think sometimes it's viewed as harsh, but when family members or even victims call in, I say, here's the deal. When you call law enforcement, you got 2 minutes, you got 5 minutes max, but really you've got 2 minutes to tell your story. And what I find is that family members, concerned folks, victims will call me and 15 minutes later, they're still talking. So I stop them and I say, here's the deal. Most people have a 5-minute attention span. You've been talking for 15 minutes. If I were law enforcement, I would have stopped listening about 12 minutes ago. You've got to shorten up that story. Very hard for people to do, especially when this is so impactful in their lives and they feel so strongly about it. And it's such an emotional thing. But I do think that's part of the problem, is that law enforcement doesn't have the bandwidth to hear those stories. You lose them at the beginning, and then they end up saying it's civil and kicking it out. Not an excuse, just the reality we're dealing with. We also have the problem of people are calling because they're concerned about someone. They don't necessarily know all the facts of that person's life. They haven't reviewed their bank accounts. They don't know what's going on in the house. What they are reporting are what I call soft facts. They're not hard facts. It's like, I think, I sense, I feel like this isn't passing the smell test. So they're not coming in saying X, Y, and Z is happening, and this is a violation of X, Y, and Z statute. They're coming in explaining what's going on from their perspective, often not having hard, fast facts for us. And I think that is causing a lot of the problems. And I will often talk to family members or victims before they call law enforcement to say, look, here's what you've told me, and here's what I'm going to pick out from what you've said that is most impactful when you tell me the story. Now, stick to those 5 words and just keep repeating those 5 words when you make the report. We often do the same thing with our adult protective services. When we give presentations, we hand out, here's the checklist that the adult protective services workers are using. Use these words. Make sure they're true, but use these words. So I think that's a big challenge, is just getting over that first hurdle of getting in the gate. We also have no check on refusals of law enforcement to take a report. I often have people call me up and say, I called the police and he told me it's civil and that was it. And I'll call up law enforcement and that officer will tell me, yes, they did report it. I don't think it's a crime. I refuse to take the report. Who's checking that? We don't have a check on that. County attorneys in Iowa, we have county attorneys, but prosecutors, 99% of them, I think, are not sitting there watching the calls that are coming into law enforcement to see if it's a valid report, if it's something that should move up or not. What I say to law enforcement is, we don't pay you to decide whether or not it's a crime. We pay you to take reports of what people think are crimes. Lawyers make decisions about whether or not it's a prosecutable charge. That's what prosecutors do. So, kindly please take the report. If it doesn't turn out to be anything, then okay. But we don't have law enforcement sitting there as gatekeepers. But that is, in fact, I think what they are doing without a check. And this isn't a slam or intended to be a slam on law enforcement. I think law enforcement often takes on far more responsibility than they should be in these cases. And that's because most often everything has fallen to them because our systems are not set up to support law enforcement any more than they're set up to support the victims in these cases. Lack of education, training, empowerment, walking right into that. Law enforcement in particular, often prosecutors as well, will have some familiarity with child abuse. Maybe they've had one or two adult cases. Most of the time, those are neglect cases that they are most familiar with. Same with law enforcement. Law enforcement, they deal with neglect cases. They deal with welfare checks. They know that stuff. Comes to a POA case and financial exploitation, brakes come on. Haven't done one of those before. Again, going back to the first slide, not thinking about these at their core. Is this a theft case? What is going on here? I've done a theft case before. How is this similar to a theft case? A lot of familiarity with domestic violence cases, not seeing a correlation between the two. And I'll tell you, when Iowa received the Abuse in Later Life grant, which I'll talk briefly about later, and we're starting to talk about domestic violence and applying those principles, I had not thought of it that way either. And it's very rare for any older person to identify themselves as a victim of domestic violence. We have 83, there was a case a couple of weeks ago, 83-year-old and 86-year-old husband. He's abusing her physically. That domestic violence piece doesn't fit in there. Same when it comes to the POA. You may have an adult son living with a mother who is violating the POA. He's abusing the POA, but people don't think about, okay, is this a form of domestic violence? Can we fit it in there? And again, we're talking about law enforcement. We're talking about prosecutors. We're talking about victim witness coordinators, few of whom have experience with these financial crime cases. So when they come in, it's like we're starting from scratch. It's all new. And again, we're not making those connections to what we are familiar with and bridging those gaps. We're applying standard investigative techniques. We're acting like when I go to this victim and I say, there's a report that your son is financially exploiting you using your POA. What do you think about that? Really? No. And I mean, these questions are being asked. And then the older person says, it's okay with me. He takes care of me. It's okay. You can't apply those standard techniques in this situation because we're dealing with dynamics that we don't see in other cases. So while it's helpful to bridge to those other cases, it isn't helpful just to carte blanche, apply those techniques, and then walk out the door and say, well, she said it was okay with her. We hear that all the time. She said it was okay with her. I don't have a victim. There's nothing I can do. There is something you can do, which is learn. Learn about the dynamics. Talk to people about these cases. We are huge advocates for law enforcement taking elder rights specialists with them. Every state in this nation has a long-term care ombudsman. Every state has some sort of area agency on aging set up. They may be different across the nation, but they're there. There are people who know how to address these issues in the sense of supporting these victims. They understand the issues that come along with aging, and they're available to assist, and they have resources that can help you move the case forward. So then we're not hearing so much of, we just don't have any of these cases, which is what we hear regularly. We just don't have any of these cases in my county, in my district, in my state. That's patently untrue, statistically impossible. Those cases are sitting out there. It's just, again, that they are not getting in the gate. They are being thrown out before anyone sees them, or they're being tossed out because the person evaluating them doesn't understand the case or doesn't understand the dynamics of these cases. So, probably preaching to the choir. You're probably on this webinar because you're as frustrated as I am, and you've heard all of these things. But those cases are out there. It's a matter of how do we shine the light on them, and how do we help these victims get through the door? And going back to law enforcement in particular, if you ask them, what is the number one thing you need in order to do these cases? What can we teach you? What do you want to hear from us? And overwhelmingly, I hear Excel. I need training in Excel. I have an accounting degree, so Excel is easy for me. I learned it in college, probably before that. So I think really Excel, that's what we're talking about here. If we help you use Excel, then all of a sudden the gates are open and everything is great. No, I think that is a symptom of the problem. That's an indication of a lack of support and understanding and training surrounding these cases. Yes, would it be helpful to be able to use a spreadsheet if you're documenting financial transactions? Sure. Most of these cases don't go that far. So putting that out there, just food for thought. When you hear that, stop and pause and say, okay, let's think about this. Why is a spreadsheet, why is a computer program, and understanding a computer program, supposedly hanging up all of these cases? It's not. So step back and think about it, and engage further. Ask, like, what's your concern? What's going on here? Welfare checks I mentioned earlier, and I like to call it the welfare check effect. Most of the law enforcement I have spoken to have told me that welfare checks are one of their top calls. That's what they're going out on, it's welfare checks. And I think what happens is they are getting calls to go into the homes of particularly older people, and they are seeing what I call social work issues. So a person maybe is having a problem with hoarding, depression, anxiety. Who knows what's going on in that house? They're isolated, all of these things. This is what on the ground frontline law enforcement is seeing most often. And that, I think, carries over when they get a POA case or a financial exploitation case. It becomes an issue of, look, this isn't, I'm not a social worker, even though we all are. I'm not a social worker. I don't do this stuff. And it becomes just that. And again, they lose that connection of there are potential crimes occurring out there. The welfare check situations, you can't apply that to all older adults. But that, I think, becomes the lens with which they look through. And again, we need to provide better support to law enforcement in those cases. We're eating up law enforcement time on welfare checks. And while we're all social workers, most of us weren't trained to be social workers if we're not, and we're not good at it. So let's get law enforcement the support they need to actually address those issues. Let's get the people in those houses that can actually help. And let's recognize that we do, in fact, have a societal issue here. But let's reserve law enforcement to do what they do best, which is to identify and investigate and support the prosecution of crimes. We have a lack of knowledge regarding witnesses and resources. I talked about this before. We don't have an established process and resource pool across the nation, not just Iowa. We don't have it like we do for child abuse. We've been doing child abuse for some time, and let's face it, children are a much more attractive population than older people. That's just how it is. We'll talk a little bit about that later. but we don't have a pool. So we're a little bit making it up on the fly sometimes, and we're reaching for ideas. We're creating ideas. We don't just have a book to open up. And admittedly, we're talking about some complex issues here. You look at a child, child abuse is horrible, and children are just as complicated as adults. But when you're talking about capacity and cognitive issues, people start, whoa, nope, we're not doing it. I don't know what that means. I don't know what that is. I don't know what I'm supposed to do. And while, again, not picking on law enforcement, but I look at law enforcement and I think, you're not an expert in capacity. You're not an expert in cognitive issues. Nobody's asking you to be that. Do you have to make preliminary decisions? Absolutely. But nobody expects you to be an expert in those things, and nobody should be treating law enforcement like they should be. Again, we have to work together, figure it out, support each other, help each other. And we have a lot of law enforcement, prosecutors, and private attorneys, the ones who prepare POAs, who really don't understand the law about POAs. I see POAs drafted by private attorneys all the time. All I can do is smack my head. Why are you doing that? I have conversations with those private attorneys, give presentations to them, and it's clear they're not engaging with us, and they're not understanding these issues, and they're not understanding the impact what they draft has in a person's life. And then we have, kind of apathy. What are we doing here? What's the outcome? What difference is it going to make? What do I hear all the time? She's going to inherit it anyway. He's going to inherit it anyway. What difference does it make? I mean, what? She's 90. What are the chances we're going to get anywhere by the time before she dies? I've had those conversations. What causes those? I have in red bolded here, ageism, right? That's a major factor that a lot of people are not talking about. We've started talking about it, but I think it's got to be number one on the list of conversation. Ageism. We have to admit it. We do have ageism. We do think that older people are fill in the blank, and we do treat them differently because of that. All of us. Even those of us with the best of intentions have this issue, and it's one that we have to talk about. A lack of community responsibility and connectedness, not my problem. Everybody wants to look the other way and say they'll figure it out. It's a family issue, right? It's a family issue. They'll figure it out. Isolation, huge issue here. We have older people who now are finding themselves by themselves. Their children live across the country. They don't have a lot of interaction with them necessarily. Their adult children are busy. They may have one adult child at home. The other siblings are relying on that person to assist their parent, which we know is a very dangerous thing. No family friends, especially in Iowa, where we have a large rural population. We have difficulty getting people transportation, access to services. Older people are ignored. Back to the ageism, flat out ignored. They've lost their relevance. They don't add anything to society. We don't pay attention to them. These are the views that people have, and this is the way that they behave, something that we have to address. We have lifestyle choices, right? Older people have their own personality. They've made choices to be by themselves. They've made choices to not interact at a high level. These are things we have to respect, but they also put people in danger. Mental health issues, huge. I say this all the time. Every time someone calls me, I say, what's going on with your parent? What's going on with the person you're calling about? Most often what I'm seeing is that older people do in fact feel irrelevant, unvalued. They don't feel like anyone cares about them, and they don't feel like they have any purpose in this world. And that's because that's how we in the royal sense are treating them. They're not crazy. They're not wrong. That is how society is stacked up. And when I did a training for law enforcement, the baby troopers, I called them the new troopers. I asked, who's the most valuable of our groups? And they said it's the middle-aged people, right? Why? Because they contribute to society. That was their answer overwhelmingly, because they provide value to society. So this is a real feeling these people have. Fear of death, a loss of opportunity. You have older people who are grieving. They're dealing with illness, physical limitations, a real fear, again, real fear of losing independence, dignity. They have stress. They feel responsible for the way that their abuser turned out, particularly when we're talking about an adult child. They're embarrassed, they're ashamed, they're devastated by these things. All of these things are happening, and we're looking at them and acting like, why can't you just tell me that it's not working for you, that you didn't want him to have your money? Why can't you just say that? Well, because there's a lot happening here. And I'd like you to look at this list. This isn't just older people. This is all of us. I mean, we act like there's a them and an us. There's only an us. There's always only an us. These things affect us as well. How many times have you felt irrelevant? I can guarantee almost everyone on this call, almost everyone has some fear of death. They're afraid of losing opportunity. They have grief. They have stress. They feel responsible for way too many things in this world. So, I put that out there so that people remember this is what's happening and this is what's stopping us up, because we're not stepping forward and saying, I recognize it and we need to do something about it in order to move these cases forward. So quickly then, a solution. We never talk about solutions, right? We always talk about why it's not working and what's frustrating us. As I mentioned earlier, Iowa was the recipient of a grant for training and services to end abuse in later life. As a part of that grant, that is, by the way, a VAWA grant, we created the Coordinated Community Response Team. That's a requirement of the grant. It is a multidisciplinary team on steroids, I say. We have right now about 150 members, which is unusual for a CCR. It's a very large CCR, but ours is statewide. We have professionals and people from just about every discipline, including some retired people. I will tell you who is missing 99% of the time, faith-based community and the medical professionals. Very difficult to get either one of those to the table. So going back to what I said earlier about mental health issues, isolation, how important are those groups? They should be at the table. They should be part of our support network. They should be out there helping us assist these victims and get these cases moving. That's the only way we get over these barriers. It's the only way we address the challenges, is we come together and work together on all of those issues as a whole, utilizing the skills each of us bring to the table. What does the CCR do? Training and education. We do a lot of training. We do a lot of education of our members. We in Iowa have monthly meetings. Most of the time that has an educational component to it, whether it's a case discussion or having someone come in and talk about what they do, what services they can provide, or to discuss what's not working or what is. Again, we do those case studies. We talk about all the John Does, not a specific John Doe, all the John Does. How does the system affect older people in general? What's working, what's not? What do we need to change? Who's stopping us? Why are they stopping us? Does it have to stop us? Or is it just because it's been done that way for 20 years and nobody has ever stopped to say, we don't have to do it that way? Those are the types of conversations we have. Those are the kinds of issues we address. Collaboration is our number one function in my mind. I lead the team and collaboration is number one on my agenda. And I say, you've got to talk to each other, know each other, understand each other, and support each other. Talk, know, understand, and support. Challenge each other. So often people would, what is the expression? They'd rather be ruined by praise than saved by criticism. And I can tell you the first 2 years of our CCR was nonstop. I'm going to say this word, bitching about our DHS, which is our Adult Protective Services. And it was valid. And they were conversations that needed to happen. And luckily, we had people in from that agency who were open to it and willing to hear it and willing to address the issues. But you've got to be willing to challenge each other. You got to step up and say, hey, you know what you're doing doesn't make any sense. Can you explain to me why you're doing it? And can we talk about whether it can be done differently? Great conversations. We are establishing MDTs and other teams, opportunities for interaction amongst folks. It has made such a huge difference now that people know each other and they can contact each other directly. I used to be the go-between for everyone. Now they're having actual conversations with each other. They know each other, they know what they do, and they help each other. Huge, huge, huge factor in overcoming those barriers. We do policy work, court forms, accessibility to those forms, intake. How does the system work, and how can we make the system work better for victims and the people who care about them? Legislation, of course, outside of the grant. Right now, for example, we have on the table an elder abuse law that would criminalize elder abuse. That is a CCR effort, and the CCR works on it and supports it. And of course, outreach is huge. Getting the message out, talking about ageism, talking about these issues, talking with each other, and really putting it out there and saying, what can we do differently as a community? You have a job, you also live in the community. I remind people of that all the time. You have two roles in this world, your job and as a member of the community. So we focus on that quite a bit. Advocacy, of course, we're always out there having these conversations, and they're tough conversations. And I have here, tough conversations equal change. We have to start talking about our fears about aging and death. We have to talk about how that shapes the way we respond to victims and the way that we treat POA abuse in particular, right? Why are we so afraid of it? Why do we step away from it? Why do we resist it? Let's look at ourselves. Let's look at society and figure out what's the problem here. Otherwise, it's just a document that supports a crime that is committed by someone. That's not novel. So I can't say enough. Working with each other and supporting each other.
Great. Thank you
huge.
So much, Tim
and that,
and
in my
Chantelle.
opinion,
This is Naomi
the
back
solution.
here. Unfortunately, we're really almost out of time.
And questions?
I'm going to take the host's prerogative to just add a couple of minutes onto this. I wanted to add one point. I think probably both Tim and Chantelle were talking about issues around private attorneys and the fact that the attorneys who draft the powers of attorney don't even understand the implications of it. One preventive step that attorneys who draft powers of attorney could raise with their clients and could build in is what I like to call trust but verify. You could actually put into a power of attorney document the requirement that the agent make an accounting to a third party, like let's say one adult child is the agent. They could be required every year, every 6 months to open the books and share the finances with other members of the family. So they would have the sense that there is someone looking over their shoulder and they can't get away with murder. So that's just one point. We had a number of questions. We won't be able to get to them all. Someone asked early on, and perhaps Chantelle, you can answer this. Someone asked whether, I guess they meant an agent under a durable power of attorney for finances can access a special needs trust that does not include that agent's name or authority. Does one of you want to answer that question?
Well, I'll take that. And I like the question because I think it highlights the issue of understanding POAs and agent authority under POAs. An agent under a POA is the same as the principal. It's the same as the person who signed over the POA. So if the principal does not have access to the special needs trust, neither does the agent under the POA. And a special needs trust has a trustee. It's set up, it's irrevocable. So that only the trustee has access to those dollars, obviously, so that we can get the principal their benefit.
That's a good answer, and I was going to say the same thing. It would have to be the trustee of that special needs trust who has that authority. We did have a number of questions, but we are over 12 o'clock, so I think we're going to have to wrap this up. We have an inbox at the Elder Justice Initiative, and it's elder.justice@usdoj.gov. I would love to try to make sure everyone's questions are answered. So if you send questions to that address, either I or Chantelle or Tim can get back to you by email. I'm glad the topic was so interesting to everyone, and I want to thank everyone for participating, and sorry for any technical issues that we had, but glad we could get through the program. Thanks so much.